Hello viewers and aspirants, welcome to Telugu One Academy. I am Anand Pawar and I am dealing with Indian polity. In this class, that is Directive Principles of State Policy, we have already done with fundamental rights, and today we will be taking Directive Principles of State Policy. This topic, Directive Principles of State Policy, is enshrined in Part 4 of the Constitution, and this goes from Article 36 to Article 51. So, fundamental rights, as we have seen, are from Article 12 to Article 35, which are in Part 3 of the Constitution. The extended part is Part 4, that is Directive Principles of State Policy. Together, fundamental rights and DPSP are regarded as novel features of the Constitution. So, Dr. B.R. Ambedkar has insisted that both fundamental rights and DPSP together are supplementary for achieving the welfaristic goal of the society and also for the development of individual as well as socialistic nature of the society. So, Directive Principles of State Policy, వీటిని మనము నిర్దేశక నియమాలు అని కూడా అంటాము. So, this article are the basic for any state. This article provides the foundation for any state for the formulation of policies. Why we call these as directive principles? Because they direct the state in the formulation of any policy. They becomes a yardstick to gauge the development of the nation. So, directive principles are important and they are supplementary to the fundamental rights of the Constitution. So, we need to know from where we borrowed this concept of directive principle of state policy. Originally, DPSP as a concept is a Spanish one. So, Spanish country, in Spain, we had this DPSP. Ireland borrowed from Spain, and we have borrowed the concept of DPSP from Irish, that is Ireland. The source of the concept of DPSP is from Irish. What we have borrowed is from Ireland. So, the directive principles of state policy together with fundamental rights are very important part in the Constitution, which gives a structured development to the nation. So, we'll move to the importance of directive principles of state policy. So, Part 4. In Part 4 of the Constitution, we have directive principles, and these are from Article 36 to Article 51. As just to remind, fundamental rights are in Part 3 of the Constitution from Article 12 to Article 35. So, directive principles will guide any state, will guide the state in formulation of their policies. So, originally we also call these, that is DPSPs, as instrument of instructions. So, they are also called as instrument of instructions, that is they instruct the state in preparing such policies needed for the governance. So, as we know, governance is the practical part of the government, that is the administration. For any country to progress, we need to have a very fine administrative agency. So, implementing of the policies are also very important. So, right from formulation to implementation, DPSP helps the government to frame such policies which could uplift the underprivileged section of the people, and there is a society where there is minimum inequality. So, all justice, that is socio-political and economic justice, is upheld. So these instrument of instructions, as we say, directive principles, will guide the state in formulating the policies which are important in the governance, that is, in running the government. So what is Article 36? As we said, DPSP start from Article 36 to Article 51. So we need to understand the Article 36. Every article is important here, as we have did in our fundamental rights. So Article 36 defines the state. It has defined the state, just to put simply, because we have already discussed Article 12 in fundamental rights. The state is defined in Article 36. As every time we use this word state, state should bring such laws. So what exactly the meaning of state is? So here when we say state, it is parliament and the union government, that is central government, state legislative assembly and state governments. We have local governments, that is rural government, urban government. We have a system of panchayat raj, municipalities, etc. And various corporations under the government, like we have corporations, aided corporations funded by the government. We have other authorities, that is other bodies or agencies which are given status in the constitution. We also call them as constitutional bodies. And we have many statutory bodies, that is they are not mentioned in the constitution, but they are created by the executive or maybe created by the parliament. So all these bodies which have a statutory force is defined under the Article 36, that is state. So when we say the state shall, that means any body, be it central government, state government, local government, or any other such agency which has a statutory force, that is defined in Article 36. So the definition of state, is defined in Article 36. It is similar or it is same as defined in Article 12. So Article 12 is the first article in fundamental rights which has defined the state, what all includes in the state. And Article 36 also defines the state in same manner as defined in Article 12. So next article is 37. So this article defines or explains about the applicability of DPSP. It is Directive Principles of State Policy. Here we say that directive principles are not justiciable. They are not enforceable in the court. Very important difference between fundamental rights and directive principles of state policy is fundamental rights are enforceable in the court. That is, if any action of the state violates the fundamental right of any citizen, then that aggrieved citizen can move Supreme Court under Article 32 and can move High Court under Article 226 Clause 1. So that is the importance of justiciable, that is enforceability of fundamental rights. Unlike DPSP, here when we talk about DPSP, directive principles are not enforceable by the court. So if any person who has not got the development from directive principles, or if someone has belief that they have not been part of this development, they cannot go to court saying that these are mentioned in directive principles, but state has not taken any action for their implementation, because DPSP are not enforceable. No one could go to court suggesting that DPSP are not implemented by the state. But one thing is clear, DPSP should be the foundation, or it should be the guiding principle in formulation of the policies. The state should consider directive principles of state policy as a basic element in whatever policy they frame. So, policies are like various types. We have defense policy, we have educational policy, health policy, agricultural policy, industrial policy, any policy which the state is formulating should have inputs from directive principles of state policy. So basically, what is the major thing about DPSP? Why it is so important that every state and its policy should be based on these features of DPSP. So DPSP primarily is enshrined in our constitution, or we have made part of the constitution because we have a plan. We have a plan to establish a socialistic pattern of society. So this socialistic pattern of society where the state will work for the welfare of the people. So welfaristic approach of the government makes it important or significant that they follow the principles which are part of directive principles of state policy. So our founding fathers of the constitution also, before we got independence, have the thought of establishing a society based on socialism. Though we have not taken the socialism as a Western concept is practiced, we have a unique style of socialism. As we say, our socialism is establishing a socialistic pattern of the society. So we generally tend towards Fabian socialism. I repeat, it's a Fabian socialism. This concept of Fabian socialism says that whatever the resources of the nation is belong to the common people or a community, and the process of development or the fruits of development should reach everyone. It's a gradual process of development. Every section of the society should grow equally. There should be a very minimum gap between haves and have-nots. So, to reduce inequality, we tend to, that is, the government in its policies or in its work, it should be the motive of the government to provide basic facilities to every section of the society. So that is Fabian socialism. So Article 37 here, when we talk about Article 37, it is not justiciable in the court. That is the applicability of directive principles of state policy. We have criticized in our previous classes, we have criticized fundamental rights. One point we need to remember is fundamental rights have more political power or political freedom. That is where we have criticized that fundamental rights do not emphasize or do not focus on social and economic concepts. So that has been the reason why directive principles of social policy have gave importance to socio-economic independence. That is, it works on the development of the community on the basis of socio-economic perspective. So here ensuring socio-economic justice is also important for the overall development of the society and individual as well. In fundamental rights, we have, as critics say, neglected socio-economic justice. It has focused more on political justice. Political justice without socio-economic justice would be rather a failure of the society, because ultimately it is the basic thing. It is the welfare of the state which needs the special focus of the government. Just not providing the right to vote, the government or the state should also ensure that every section of the people, men, women, old people, sick people, disabled, children, students, employees, every section of the society from all religions, from all regions, should be able to get the fruits of the development. That is how all three concepts, that is political justice, social justice and economic justice, should go together. That is when we could say that we have achieved justice, that is justice is prevailed. So all the three concepts should be given equal priority. So in Directive Principles of State Policy, the framers of the constitution, that is they have focused more on socio-economic justice. ఆర్థిక న్యాయం, సామాజిక న్యాయం మీద ఎక్కువ ఫోకస్ ఇవ్వడం జరిగింది. ఫండమెంటల్ రైట్స్లో మనకి ఓన్లీ పొలిటికల్ జస్టిస్ దాని మీదనే ఎక్కువ ఫోకస్ ఇవ్వడం జరిగింది. సో ఆర్టికల్ 37 క్లియర్లీ సేస్ the applicability of directive principles of state policy. So we have a small difference. Just when getting into the DPSP in detail, we would be discussing a small differences between fundamental rights and directive principles of state policy. We also call this as instruments of instruction. They instruct the government or the state in framing governmental policies. So here fundamental rights have limited scope, because we know all the aspects of the governance are not added in fundamental rights. There are many things which we have left out, because India as a country cannot afford everyone the socio-economic and political justice. For that we need lot of resources, and because we have faced lot of tyranny, lot of exploitation under the colonial regime, we could not, at that time when we are framing our constitution, we have not added most of the features in fundamental rights, because fundamental rights are enforceable in the court. So many such things are left outside, and we have placed them in directive principles of state policy. That is the reason why I say that any government which formulates the policy should consider both fundamental rights and DPSP as well in framing its policies. They are equally important. It doesn't mean that DPSP are not enforceable in the court. The state will neglect it. If any state neglects directive principle of state policy, the real achievement will be just a dream. It cannot be a reality, because when we talk about welfare state, when we talk about socialistic pattern of the society, any policy should have the features which are mentioned in directive principles of state policy. So we have very limited scope in fundamental rights. Here scope is limitless. So when we read article 38, 39, 40, all those DPSPs, we could witness many things. It's very vast, diverse in nature. It focuses on all aspects of an individual, of a society altogether. So the scope is very large, wider than fundamental rights. So when we say fundamental rights, generally they are negative. Why we say negative or prohibitive? Because fundamental right stops state from bringing such law which could violate the fundamental rights or natural justice of any citizen. So every time the court will ask the legislature to not bring such laws which invalidate the constitution. If any law of the state or any legislation is against the spirit of the constitution or which takes away fundamental rights or abridges the fundamental rights of any citizen, such law can be declared as invalid. So, we say fundamental rights generally put a restriction on the state for bringing such laws which are not inconsistent with constitution. So, that is the reason why we call fundamental rights as prohibitive. They prohibits states' action. As we have discussed many Supreme Court cases where an individual or a citizen whose fundamental rights have been taken away or abridged would move the Supreme Court or High Court saying that my fundamental rights has been taken away by the state and its policies. Then the Supreme Court will enforce those fundamental rights because it is the duty of the Supreme Court as a guardian of the Constitution, as a protector of the Constitution. Supreme Court enforces the fundamental rights. So, states are always restricted from bringing such law or passing such legislations which are against the fundamental rights. When we say we have the right to freedom, right to free speech and expression, and if there is any policy by the government which restricts our freedom, then the aggrieved person will go to court. That is not in the case of directive principles of state policy. So we say fundamental rights are negative or prohibitive in nature because they put limitations on the state. The states are being restricted for passing such law. In directive principles, we say they are affirmative. Affirmative in sense, they add a positivity in the framing of the policies. The state should ensure that whatever policies they bring for the good of the people, for establishing an welfaristic society, they need to get influence from the directive principles of state policy. Here DPSP will guide the state. They will add an advantage in making the state to bring such policies so that every section of the society is happy with that and there is an overall development in the society. So the concept of egalitarian society or welfaristic society is upheld. So that is affirmative directions. These provide direction, or these DPSP are the instructions to the state in framing policies. So when we say welfaristic state, it is a very wider concept. ప్రజా శ్రేయస్సు కోసం ఒక ప్రభుత్వం చేయాల్సిన పాలసీస్ ఎలా ఉంటాయో, జనరల్గా ఇది మనకు అర్థశాస్త్రాల్లో కౌటిల్య మెన్షన్ చేసిన కొన్ని ఉంటాయి అర్థశాస్త్రాల్లో. సో టు ఎస్టాబ్లిష్ అ వెల్ఫేర్ స్టేట్, the government should strive to bring a uniformity, to lessen the inequality, to provide basic facilities to all the section of the people, to make the natural resources available to everyone, to decrease or to lessen the concentration of wealth in the hands of few members. So all these steps are taken by the government so that there is a socialistic pattern established in the society. So one important difference is they are enforceable. Fundamental rights are enforceable in the court. The court will order the state to enforce the fundamental rights, and at times the court will negate such law or will declare invalidate such law which is not consistent with the constitution. Whatever provisions we have in the constitution, if the law passed by the legislature is not consistent with the provisions of the constitution, then the court could declare such law as invalid. So that is where enforceability is important. We have discussed the types of writs. Writs are the tools by which the court enforces fundamental rights. DPSP are not enforceable by law. So, court does not have power to enforce directive principles of state policy. Because directive principles are very vast in our country, as we have very diverse society, we have multi-religious society, we have caste system, we have a very diverse geographical entity too. So, we cannot enforce all those provisions mentioned in the directive principles because we need lot of resources for that, be it natural resources, be it intellectual resources, and we need to get out of so many social evil things like illiteracy, poverty, malnourishment, etc. So, we have not made DPSP as enforceable by the law. But important thing is, every policy of the state should be in line with or should be inspired by the provisions mentioned in the Directive Principles of State Policy. So that is why we say fundamental rights are enforceable. They have very limited scope. DPSPs are not enforceable because there are many such provisions in the constitution where we cannot enforce every provision mentioned in the DPSP. So I say fundamental rights and DPSP are supplementary to each other. They are not contradictory. They are supplementary. They should go hand in hand together. We cannot demarcate that fundamental rights are enforceable, so more importance is given to FR fundamental rights, and DPSP are, because they are not enforceable in the court, they could be neglected. No government survives if they neglect directive principles of state policy, because as we know, we have a system of elections, and every party before coming into power, they will have their manifesto, and many things are given or they have mentioned in their manifesto regarding their coming policies. వారు ప్రభుత్వంలో వస్తే ఎలాంటి పనులు చేస్తాము అనేది వాళ్ళు ముందస్తు వాళ్ళ మేనిఫెస్టోలో పొందుపరుచుకుంటారు. ఆ మేనిఫెస్టో ఏంటి? ఆ మేనిఫెస్టోలో చాలా వరకు డిపిఎస్పికి సంబంధించి ఉంటాయి. వెల్ఫేర్ స్టేట్ కానివ్వండి, ఒక వెల్ఫేర్ స్టేట్ కావాలంటే ఉచిత విద్య కానివ్వండి, ఉచిత వైద్య ఆరోగ్యం కానివ్వండి, మంచి రోడ్స్ ఎస్టాబ్లిష్ చేస్తాము, లేదంటే ఉపాధి కల్పన కలిగిస్తాము, లేదు అంటే పెన్షన్ స్కీమ్స్ తీసుకోండి, వృద్ధులకి పెన్షన్, నిరుద్యోగులకి పెన్షన్, డిసేబుల్ పర్సన్స్కి పెన్షన్, ఇలా చాలా వరకు వాళ్ళ మేనిఫెస్టోస్లో ఏ పొలిటికల్ పార్టీ అయినా పొందుపరుచుకుంటాయి. ఒక్కసారి ఎలక్షన్స్లో గెలిచి పవర్లో వచ్చాక అలాంటి వాగ్దానాలన్నీ నిరూపించుకుంటేనే నెక్స్ట్ టైం ఎలక్షన్స్లో ఓట్లు వస్తాయి. సో వీ కెన్ సే దట్ నో గవర్నమెంట్ కుడ్ సర్వైవ్ ఇఫ్ దే డు నాట్ ఇంప్లిమెంట్ డైరెక్టివ్ ప్రిన్సిపల్స్ ఆఫ్ స్టేట్ పాలసీ, బికాజ్ పీపుల్ హ్యావ్ పవర్ టు చేంజ్ ద గవర్నమెంట్ ఎవ్రీ 5 years and no party will take any risk to avoid the provisions mentioned in Directive Principle of State Policy. Even we have in Preamble, we have mentioned in the Preamble that we are a socialistic society. Our preamble says India is sovereign, socialist, secular, democratic republic, and justice of socio-economic political justice should be given. So that is the importance, and all those things are mentioned in DPSP. So it is not part of any government to avoid or to neglect the provisions mentioned in DPSP. Because they are not enforceable, that does not mean that they are given lesser importance. Both have similar significance. They go hand in hand. When I say fundamental rights and DPSP are supplementary to each other, they both go hand in hand. And one thing is, DPSP are not subordinate to fundamental rights. But there are many cases in Supreme Court where there was a discussion between the importance of fundamental rights and directive principles of state policy. The court rulings said that both have equal importance. The fundamental rights and directive principles have been given equal importance. The only thing is, when there is a question between the significance of fundamental rights and DPSP, or when there is a sense of conflict, then obviously fundamental rights would prevail, because we have given it a special status in terms of enforceability. First, fundamental rights would prevail when there is a conflict arises between fundamental right and provisions of DPSP. Otherwise, in normal circumstances, both need to be given equal importance by the state in formulation of its policies and in the process of governance.